I am.
Good morning. In front of the court, what is the status of this matter?
The plaintiff has a support amount of $89 and a balance of $908.50. The last payment was received in November, August, and September in the amount of $100 each. The plaintiff requested friend of the court to contact her as a reminder to pay in November when she made a payment. The office left a message on December 26th, but no additional payments have been made. The friend of the court seeks guidance today on how to proceed.
Thank you. Miss Foster, is it?
Yes, sir.
All right. What would you like to say regarding this matter, ma'am?
Here as of late, I had injury, and then had surgery. I'm still recovering from, so I haven't been working as much. And then I had borrowed money to at least put $100 on it just recently, but then ended up having to use it to put food in my home. Just kind of going through the struggle right now. But I do plan on making a couple $100 payment within the next couple of weeks, at least.
Okay. It does look like you're behind then for December, January, and February is almost over, but not quite. So you think you could pay a couple $100 in the next 2 weeks? Is that correct?
Yes, sir.
Okay. What we'll do is adjourn your case to March 20th to monitor if that payment is made and where you are at with the upcoming and ongoing payments. Do you have any questions, ma'am?
No.
All right. We'll see you back here March 20th. Thank you.
All right, thank you.
Parties on that matter present?
Yes.
Yes, Your Honor.
Good morning. In front of the court, what is the status of this matter?
The defendant has a support obligation of $375 and an account balance of $2,873.66. There has been no payment since October of 2023. That payment was $333.16. And previous to that, $369.33 was paid in June. The friend of the court seeks guidance from the court on how to proceed.
Thank you. Mr. Corbin, what would you like to say regarding the status of this matter?
The reason is I was enrolled into Veterans Treatment Court. So my job requires me to leave the state of Michigan. So the part of the requirement for the program was for me to stay in state. So I wasn't able to work. I have now recently been working. So a payment did go out on the 6th of this month.
How much was that?
$197.
Okay. And what is it that you're doing for work now?
I modify steel towers. That's what I've always done.
All right. Are you self-employed or are you working for a company?
I work for a company.
Okay. And who do you work for?
Track Solutions, TRAC.
Have you provided that information to a friend of the court yet?
Yes, I believe they do. I've worked there for the last 12 years.
All right. I guess I got confused there. So I thought your employment changed or something like that. So you had the same employer that you had before?
Yes, I have the same employer. I just, because of the program, I wasn't able to leave the state of Michigan, which my job requires me to.
All right. So you had a period where you couldn't leave, you weren't able to leave the state, so you weren't working hours. Is that what you're saying?
Yes, I wasn't working at all. I don't have a driver's license, so to find temporary employment, there's a challenge.
What kind of hours? Kind of hours are you working now?
I usually work like 60, 70 hours.
All right. When did that start back up?
January 21st of 2024.
Okay. For the court, have you received any information from Mr. Corbin and been able to look into an income withholding order?
If it was a prior job, they should send money in, but when I got this together, there wasn't anything yet.
Okay.
So if it was a previous employer, they should withhold money. It just may not have hit the system yet.
Right. So Mr. Corbin, that payment that you said on the 6th, was that a payment that you made or that you're saying was taken out of your check by your employer?
It was taken out of my check.
Okay. All right. What I'm likely to do is adjourn the matter to see where we're at with the income withholding order and make sure that's happening. Ms. Corbin, do you have any questions or any comments that you would like to make?
No, I mean, the only thing that I would add is I'm okay. I mean, while he's been back and not working because of what's been going on, he has been helping with the kids. So I'm not opposed to dismissing what he owes to me for his child support and just take care of what he needs to take care of for the state side. Because he has been helping tremendously. So.
Okay. So right now there's a $2,800 or so that's owed. Is that correct?
Yeah, but it could be potentially owed to the state.
Sure. Some of that is there.
Yeah.
So Ms.
So
Corbin,
whatever's owed to the state.
Okay. You want to waive any arrears that's owed to you at this time?
Yeah, I'm okay with that. Like I said, he's been very helpful. We have a good co-parenting relationship. And if this helps him, then this helps me and it helps the kids. So.
And what about ongoing payments?
I think we have to. I went to the front of the court yesterday and got some information. So I was just taking one step at a time. Today I was okay with just saying that I am good with him not having to take care of what he owes for child support to me.
Okay.
That he's
Mr.
back
Corbin, Mr. Corbin, do you have any objection to waiving the arrears that are owed to Ms. Corbin?
No, absolutely not. And I also want to add, last year, the state of Michigan withheld my tax return. So this year, I'm assuming that they would do the same thing, which I'm all right with. So I would assume that's going to be processed shortly.
All right. In front of the court, do you see any issue with waiving the current arrears that are owed to Ms. Corbin, but continuing the support amount at this time?
No.
All right. All right. So given the statements from Ms. Corbin, that's what we'll do. We will also set this matter for March 20th, just to make sure that income withholding order is in place and everything is happening as it should. Any questions, Mr. Corbin?
No, not at this time, Your Honor.
All right. Ms. Corbin, any questions?
No.
All right. Thank you both for appearing. That does conclude your matter. You may sign off.
Thank you.
We do have, I'm sorry, it's Ms. Doyle. We have Ms. Doyle present. In front of the court, what is the status of this matter?
The defendant has a support obligation of $925 and an account balance of $6,829.85. A payment of $550 was received in October of 2023. The front of the court would seek direction from the court on how to proceed today.
Thank you. Ms. Doyle, any questions or any comments that you would like to make?
Not really. I'd kind of like to know why he hasn't been paying. I know part of that is to go to childcare to help offset the amount that I pay. But other than that, I don't have anything.
Thank you. All right. Well, given Mr. Higdon's failure to appear, as well as his failure to pay the arrears in this matter, I will recommend the issuance of a bench warrant in the amount of $1,725 plus $100 in costs. Any questions, Ms. Doyle?
Not at the moment.
All right. Thank you. Thank you for appearing. That does conclude the matter.
Thank you.
If either party is present, please unmute and identify yourself. It does not appear that either party is present. In front of the court, what is the status of this matter?
Case was adjourned from January 10th, 2024, with the stipulation that the defendant needed to pay $1,200 before today. No payments have been made. He does have a support obligation of $558 with $50 ordered on arrears. Current balance on the account is $9,529.39. Last payment received was in December of 2023 in the amount of $49.45. And we have spoken with the defendant several times regarding his concerns about paternity or how to potentially lower support. He's been given all the options to do that and was also reminded of today's court date. Due to his failure to appear, we are seeking a bench warrant in the amount of $2,300 plus 100 court costs.
Thank you. Given defendant's failure to appear, I will recommend the issuance of a bench warrant in the amount of $2,300 plus $100 in costs. If either party on that matter present.
Yes, I'm here.
Good morning. In front of the court, what is the status of this matter?
This is an arrears only case. Current balance on the account is $3,990.89. Last payment received was in October of 2018 in the amount of $200. The defendant does have some ongoing medical issues, and we've been asking him to supply some documentation to potentially look at maybe doing an abatement or working with him on the support amount or the arrears amount that he's responsible for paying on. We are still waiting on paperwork from his attorney, and we have not received anything yet. And he's also having some hard time getting some of the paperwork required for us to look at other options for him to work with him regarding his situation. So at this time, we are seeking to potentially adjourn the hearing out a little bit further to allow him more time.
Thank you. Mr. Morris, what would you like to say about this matter?
Yeah, I'm just trying to get something from my attorney. I've been fighting for disability for a while now, and I got heart issues and memory problems and then just having a hard time with medical conditions.
Where are you at in the disability process? Have you applied and then been initially denied? And
I applied, and he'd filed an appeal. Not for the jail judge, but the second time.
Have you had a hearing in front of the judge yet or not?
No, not yet. No, okay. Nothing with that yet.
And that's not scheduled yet?
No.
Is there a reason you can't get some documentation to the front of the court showing that you had that ongoing case, as well as any medical records that support your inability to work?
Well, the doctor took my license away, so the only transportation is taxi through my insurance company, which I can get some documentation, but it's going to be a while. I'm still waiting for referrals because I moved here from Florida back to Michigan, and they referred me some referrals for more doctors, and I'm just waiting for the referrals to call me too. But I can get some documentation.
Do you believe you can't work at all, sir?
No.
All right. I'm going to give you another chance to get the documents, but without the documents, you need to show that you have an inability to work beyond just what you're telling us. So I'm going to give you another shot to get that paperwork. If we don't have that paperwork, given how long it's been since the payment, we'll have to consider a finding of contempt if we don't have the support to show what's going on that prevents you from working. So I'm going to adjourn your case. I'm going to give you a little bit of time. I'll go to April 17th. So you got about 2 months to get something together and into the front of the court before that, okay?
Mm-hmm. Yep.
All right, we'll see you back here on April 17th.
Oh, good. We all done then?
That's him or not?
I got it, Your Honor. Sorry. I don't use Zoom, so can you hear me now?
All right. Yes, sir. You're Mr. Stefani?
Yes, Your Honor, I am.
Thank you. Front of the court, what is the status of this matter?
This is an arrears only case. He currently has an order on arrears for $101. Current balance on the account is $15,993.63. Last payment received was in October of 2023 in the amount of $282. I have been in contact with the defendant, and he stated that he was homeless but has just found a new job. We do have an income withholding set up. We're just waiting for that to start drawing money out of his paychecks. So considering that matter, we'd like to adjourn to monitor payments.
Thank you. Mr. Stefani, what would you like to say regarding this matter?
Just that I just had a rough time, and that's why I wasn't able to make payments, but everything's back on track now. So, okay. And I apologize.
Wait at this time?
Yeah, I'm at work right now, sir.
All right. Well, what we'll do then, sir, is adjourn this matter to March 20th just to monitor that income withholding order and making sure that those payments are coming in. If everything's going smoothly, then that'll probably be the last time you got to be here, okay?
Okay. I have one question. How much is the payment still going to be the normal amount, or is it just going to be the $100 every month for the arrears?
Well, as of now, it's just $100, correct? Correct, front of the court? Right. Okay.
So that'll be $100 taken out every week? Or, I mean, throughout the month, I mean?
I think it's a monthly payment at this time.
It's one-on-one ordered on arrears, but he has a sizable balance too, so it may potentially take a little bit more outright.
I guess we could request to see what he can potentially pay, since due to his high arrears balance, if he can suggest an amount more than that because of the $15,000.
What we'll do is we'll come back here March 20th, make sure that income withholding order is working, and then we'll address whether or not we need to look at increasing your payment given the large balance. Okay.
Okay.
All right. Thank you.
Thank you.
To either party on that matter present.
I'm Pamela.
Good morning. In front of the court, what is the status of this matter?
The defendant is ordered to pay $211, has a current balance on the account of $7,480.43. Last payment was received in October of 2023 in the amount of $280.92. We have tried to contact the defendant, however, his phone number does appear to be disconnected. Due to no previous failure to ocurrs, we would like to adjourn for additional time to try and locate him.
Ms. Sylvester, any questions or comments you would like to make?
I have his Oklahoma address for him. He was here through the summer and spent time with the kids. First time he's actually spent time with them since 2017. It was a rough ending. He had to go back to Oklahoma to finish his domestic violence case out there. Hasn't been back, and we've gotten a couple messages, but that was it.
Okay, are you willing to share that address with the court? And what we would do is send out a new notice and adjourn this matter?
I do not have it with me. It's on my phone. I got to look it up. I did put it on his return mail address because he decided to change his front of the court paperwork to my address. And I'm not allowed to change that.
After this hearing, if you could just at some point today call front of the court, provide them with his updated address as well as any phone number that you may have for him, that would be appreciated. And I will adjourn this matter to April 10th.
Yes, sir. I will do that.
Thank you. I appreciate that. All right,
Thank you.
You're all set, ma'am, and you can sign up. 175.
Have a good day.
Yes. Thank you to either party on that matter present.
Thomas Burden checking in.
Thank you, sir. For the court, what is the status of this matter?
This matter was adjourned from January 17th to monitor the defendant's attempts to secure employment. He currently has a balance on his account of $7,810.58 and a support obligation of $184 plus $50 ordered on arrears. Last payment was received in September of 2023 in the amount of $124.71. I have been in contact with Mr. Burden regarding his employment search. We talk roughly twice a week regarding his attempts to secure employment. He has shown that he is taking the matter seriously. However, as of yesterday, when I last talked to him, he still hadn't secured anything, but was still actively looking.
Thank you. Mr. Burden, what would you like to say?
Everything stated is correct. I've been very adamant trying to find employment. I've been applying to new jobs weekly, if not daily. I've been in contact with my caseworker, keeping her posted what's going on. And currently, I might be getting a job up at the Ramada here in Grayling. They haven't hired anybody for sure yet, but it seemed promising at my interview. Other than that, I'm still actively looking for other avenues of employment in the meantime.
All right, thank you. All right, well, given the contact you've had with your caseworker, and she's vouching for your attempts to seek employment, what I will do is adjourn this matter to April 10th to see where you're at with that search. And I would just ask that you continue to keep her updated. Any questions, sir?
No, sir. That sounds good. Thank you.
All right, thank you. You're all set.
All right, have a blessed day.
I'm present.
Brother Martinez is present, Your Honor.
Okay, we do have both parties present. In front of the court, what is the status of this file?
The defendant has a monthly support obligation of $695. Current balance on the account is $6,341.38. Last payment received was in December of 2023 in the amount of $700. I have tried to contact Mr. Martinez, however, it appears the phone number we have is no longer valid. if we could please get an updated phone number for him. And then we would also like to add additional monies on his orders on arrears due to the current account balance.
Thank you. Mr. Martinez, what would you like to say regarding this matter?
Momentarily, Mr. Legal, I am seeking for work. I have many applications turned in, but I've been denied for many reasons. But I'm also self-employed, so I am trying to make money and pay my responsibility. But unfortunately, it's winter time, so doing roofing, I'm not getting many jobs at the moment. So I'm kind of stuck. I'm still trying to get jobs. I'm still doing my best, but I'm not getting hired.
All right. Have you had a recent change in your phone number, sir?
Yes, sir. I can actually give it to you guys at the moment if you guys need it right now.
Yes. Thank you. Thank you.
No problem.
Have you had any income the last month and a half or so, sir?
No, sir. Last time I had income, I started working for the roofing company around May 23. So I'm still working on my accountant to get back with my taxes so I can give that information to the courts. Because I've been 10. Excuse me?
Do you expect to have some money coming back through your taxes?
No, I'm having to pay in.
Okay. When do you expect things to pick back up, sir?
I'm hoping here in the next month or two, Mr. Legal. Springtime, summertime. But momentarily, I'm still looking for a part-time job as well. So I haven't stopped looking since I got let go November 22nd. But I'm struggling. I can guarantee you that.
Okay. Ms. Canterbury, do you have any questions or any comments that you would like to make?
No, Your Honor.
Okay. All right. I'm going to adjourn this matter out a little bit, give Mr. Martinez a chance to show the court that he's going to get out there and find some type of ability to make some payments here. I'm going to adjourn you to April 10th.
April 10th.
So, Mr. Martinez, I would expect when we come back at that time that you'll be able to show that you've made an effort to get some money in on this account. And then we'll also address at that time the need to perhaps up your payment a little bit to deal with the back amount that is owed. You have any questions, sir?
No, sir.
All right. Ms. Canterbury, any questions?
No, Your Honor.
All right. Thank you both for appearing. That does conclude the matter, and you may sign off. Either party on that matter, present.
I'm here, Your Honor.
All right. We do have Mr. Totten present. Sir, did you expect Ms. Totten to be present?
So due to her moving, she just moved back to Gaylord from Grayling, and she tried to switch her address with the post office, she told me, and she wanted me to let you know that the post office is saying that they can't verify her identity, so that we're been still sending mail to our old address. And I recently just went to Grayling and picked up our mail as of 2 days ago from the old address. And so we just found out about this 2 days ago. Luckily I was able to get in right now and talk to you so I could say something, but I tried to call this morning and let you guys know that we wanted to still go through with the case, but we need to know if it would be possible if we can adjourn it for another couple weeks or something, just so we could get into good standing again and be able to have everything in order that we need to have for us both to talk to you and establish a good parenting order and everything like that.
All right. Do you have her current address?
Yes.
What is her current address?
Gaylord, Michigan. And I have a new phone number for her as well, if you would like to take that down.
Yes.
Okay, so her phone number is 23.
Okay. In front of the court, do you think you need any additional information from Mr. Totten? No, okay. All right. Thank you, sir. I appreciate that information. What we will do is we will adjourn this matter out about a month. You and Ms. Totten will both be sent a new notice. So Leah, we'll shoot for about that 30 to 45 day range to give you guys a chance to have further discussions and then come back and let the court know what the status is. Okay.
All right. Thank you so much.
All right. Thank you. Have a good day.
You too. Bye bye.
Your Honor.
Yes.
Did you want to address that one?
Oh, I did. Yes.
Yep.
Of course, we go back on the record in the Amanda Doyle versus Ronald Higdon matter, file number 21-18671 DM. Court had called that matter earlier today. Mr. Higdon did not announce his presence, and the court recommended the issuance of a bench warrant. On break, the court was advised that Mr. Higdon was having difficulties signing in. He was in contact with the front of the court office regarding the issue, was given an alternative method, but was unable to sign in at the time of his hearing. Given that he was making the attempt to appear, I will rescind the recommended bench warrant, and we will renotice this matter for March 20th. That does conclude the Higdon matter. DC. Ms. Thompson, can you hear me okay?
Yes.
Thank you. And Mr. Blumberg, if you could place your appearance on the record.
Thank you, Judge. Elliot Blumberg on behalf of the plaintiff who's appearing via Zoom from my office.
Thank you. And we are here on a motion filed by Ms. Thompson. I do see that Mr. Blumberg also filed a motion regarding custody. There's also a request to address potentially the paternity of one of the children. Ms. Thompson, you're the plaintiff, so I will start with you. What is it that you are asking of the court?
I am asking for specifically parenting time to be established, and then I'm open to 50-50 custody of both children as long as Mr. Reduce stays consistent. He's been kind of in and out, and then he has also denied paternity of our daughter. So I would like to get that addressed as well.
Do you dispute that he's the father of that child?
No.
All right, thank you. Mr. Blumberg, from your perspective, where are we at?
Well, Judge, my client has acknowledged paternity. He signed an affidavit of paternity. He took a DNA test that established 99.9% that he is the father of Aviana. So that's not an issue. There has been no order establishing paternity. That's one of the requests that we're making of the court.
All right. I know at one point that child was added to this case. I guess didn't specifically establish paternity, but we will get that addressed then, since there is no parties are in agreement that he is the father of the youngest child. And then, Mr. Blumberg, you're seeking to change custody or parenting time? What are you seeking to do?
Well, there is no order of custody or parenting time for Aviana. Judge Hunter denied Ms. Thompson's request for an ex parte order, and in his order, he acknowledged and pointed out there was no custody order or parenting time for Aviana. But if the parties are agreeable, we would certainly stipulate right now to a joint custody, both physical and legal custody of Aviana, with a specific parenting time for both children of a week on, week off.
Ms. Thompson, is that something you're looking to agree to it today?
As far as Jordan goes, I would be open to week on, week off. As far as Aviana goes, Tony has not had her more than a few hours at a time, let alone overnight. So I would not be open to agree to that as far as Aviana goes. I feel like 3 days maximum for her to start would be doable.
Mr. Blumberg, what are your thoughts on trying mediation to see if the parties can get somewhere? It sounds like they're not too far off.
Yeah, I think that would probably be a useful use of the court's time to order the parties to mediation. And so it sounds like we have an agreement, at least as to Jordan, of both joint physical, joint legal with equal parenting time. And I understand, if I'm correct, that there's a similar agreement as to custody as to Aviana, but the issue of parenting time would be referred to mediation.
Is that correct, Ms. Thompson?
Correct.
All right, so you're ready to move forward with the joint, with the parenting time being week on, week off for the oldest child at this time?
Yes.
Okay. Do we need to address what kind of, when you guys would switch and that type of thing, or has that already been discussed, Ms. Thompson?
That has not been discussed. I'm open to whatever Anthony would like to do. I think Sundays would be beneficial, so we both get part of the weekend.
On Sunday.
Okay.
I'm sorry.
Monday to Monday.
My understanding is he is requesting the exchanges on Monday. So every Monday the exchange would take place.
That would be fine. Then we could do it through daycare as well.
Okay. All right. Now I'll take some brief testimony from the parties regarding the portions that isn't in agreement. Ms. Thompson, I'm going to start with you. So Ms. Thompson, are you asking this court to enter a stipulated agreement between the parties wherein you agree that the parties would share joint legal custody for both children? Is that correct?
Correct.
And you would have joint physical custody of the oldest child, Jordan. Is that correct?
Correct.
And as to Aviana, that matter, you're agreeing to go to mediation to discuss the physical custody of Aviana. Is that correct?
Correct.
And for Jordan, you're agreeing the parenting time would be week on, week off with exchanges to take place on Mondays.
Correct.
And do you feel this agreement is in the best interest of the children?
I do.
Have the two of you talked ever, ma'am, about holidays and how you would handle holiday parenting time?
No.
Okay. I think we can leave that perhaps to the mediation discussion too, since the parties are going to go there. And sir, are you also asking this court to enter a stipulated order that would give the parties joint legal custody of both children?
Yes.
And as to the oldest child, Jordan, at this time, there would be joint physical custody with a week on, week off parenting time, exchanges to take place on Monday. Are you in agreement with that?
Yes.
And are you in agreement to go to mediation to address parenting time for the youngest child?
I am not open to mediation because I've talked to Ms. Thompson about getting my daughter and she's denied me for having her. I don't feel like we need to go to mediation. I feel like we can solve this and I should be able to get the same as what I have as my son. I'm a responsible adult. She's over a year old.
Okay. Well, we can't have that hearing and that decision today. I can give you guys a hearing date if that is what is the request. Mr. Blumberg, are you requesting a hearing date then on this matter?
Yes, Judge, but with the hope that between now and the ultimate evidentiary hearing, the parties can come to some type of agreement. And if they did, we would certainly inform the court of that.
Okay. So, Ms. Thompson, he's not agreed to the mediation portion. Are you still looking to go forward and agree to the other terms, ma'am?
Yes. I would also like to add, as far as our youngest child goes, I have asked Mr. Produce to take her many times. We've gotten on a schedule where a couple days.
Okay. That's something I'll deal with that in a hearing, and let's parties reach an agreement. All right. Okay. So, Mr. Produce, note then we won't do mediation. We will do an actual hearing date then as to any parenting time for the youngest child. Do you feel that this agreement is in the best interest of the children at this time?
Yes.
All right. Mr. Plumber, how much time do you think you need? Are you looking for a 3-hour block, or I do have a 2-hour block on March 18th.
Yeah, I'm fairly certain that date doesn't work for me. If you just hold on a second. I think only 2 hours is going to be necessary given the age of the child. Let me just take a look. A 3-hour hearing in the Charlevoix County Probate Court that afternoon.
Okay, so then my next multiple hour block is April 24th at 1 p.m.
Yeah, that's fine.
All right, so we'll set this matter then for April 24th at 1 p.m. That's an in-person hearing. That is to determine the physical custody of the youngest child. The front of the court will prepare the other portions of the order that the parties have stipulated to today. I will withhold making any new modifications to the support order at this time, because that actually was based on equal time for the oldest child. So until we know what we're doing with the youngest child, there's no need to make any changes to the support order at this time. Mr. Blumberg, anything additional you think we need to address today?
I don't think so, Judge. Thank you.
All right, thank you.
Your Honor.
Ms. Tom?
The hearing that's set for March 20th.
Yes.
Well. Okay.
Ms. Thompson, do you have any questions, ma'am?
I do. So going forward until that hearing, how do we go about Aviana? If we can agree to a time that, okay.
Okay. That's for the parties to discuss and figure out. I will indicate that. So, Mr. Blumberg, you had a date on for this case on March 20th on your custody motion. The parties don't need to appear for that because we'll obviously hear that motion at the April 24th. We'll have the evidentiary hearing on April 24th at 1 p.m. So the hearing for March 20th at 10:15 is removed.
Very good. Thank you, Judge.
Thank you. Thank you both. Are the parties on that matter present? So please unmute and identify yourself.
I'm Cody Brando.
Brianna and I.
Thank you. And Mr. Brando, I do need to take your hat off. I know you're not formally in the courtroom, but we do consider it an extension of the court. And Mr. Brando, this is your motion regarding parenting time. Is that correct?
Yes, sir.
All right. And what are you seeking to change, sir?
I'm seeking to, I was informed yesterday that I have supervised visits already. And I would like it to be placed on the record in certain times that I can have me and my mother go and see my daughter.
All right. So there's an open case in the probate court, or where do you have the supervised visits through?
My Shasta told me that I have supervised visits through you guys.
Okay. All right. I thought you were saying there was some other order that was just recently done when you said I was told. So
no.
The last order in this case said that upon release from jail in the Lion's Den, defendant to have supervised parenting time until further order of the court. Defendant can have contact with the child via mail, email, text, or phone calls. And it said the defendant, well, first the defendant's parenting time is suspended until the release. So when were you released, sir?
I got released in October of 21st of last year. And I was trying to avoid dealing with the courts and trying to deal with her mother. But she's been telling me that I don't have any rights and my daughter doesn't want to see me. So I'm just trying to establish, I know that they need to be supervised. But I would like to see my kids.
All right, Miss Nye, I'm not sure what you're doing on your end, but we are getting feedback through your connection. So I don't know if you've got a second device on or what you've got going on, ma'am, but if you can make that stop, that would be helpful. So Mr. Brandow, are you asking them?
So I don't get service at my house, and I'm using Wi-Fi for a connection. I know that sometimes it does give like a rebound voice, but I don't have any other way to communicate on anything else.
Okay. All right. So Mr. Brandow is seeking some sort of parenting time schedule. Ms. Nye, what is your position on that request?
So back when he was incarcerated, I did take him to court to terminate the parenting time until he was released. That was an agreement. I have allowed him to try to see his child since he got out. I actually drove Anaya to Gaylord, and I was informed that he was going to have lunch with her and also take her to her dentist appointment where I would not be present. I allowed him to do those things. He ended up bailing last minute and said, I have to go get my girlfriend from rehab. So that was kind of like my last straw. I wasn't going to try and help anymore because this has been a reoccurring thing. He says he wants to see his child, and then when given the opportunity, he bails. And Anaya feels strongly about that as well because it's been done to her. I asked her, do you want to see your dad? We can set up a time. She tells me no. And I remember when we went back to court the last time, it said that, it was a agreement kind of thing. And I don't feel comfortable letting her see him if she doesn't want to.
It's not. Thank you. All right. I don't need to know all that information. I was just trying to see if the parties have a ability to resolve this on their own or have an agreement. Since you don't, what we'll do is we'll set this matter for a evidentiary hearing. That is an in-person hearing, meaning you both will have to be here in person in court, as well as any witnesses that you wish to present. Given the child's age, I will also meet with her that day prior to the hearing. We're going to set this for Monday, March 18th at 2:15, unless either of you have a previous vacation or something where you're out of the area. Mr. Brandow, are you available March 18th?
Absolutely.
All right. And Ms. Nye, are you available March 18th?
Yes.
All right. All right. We'll send you a notice, but it'll be March 18th at 2:15. I do need, again, minor child should be brought to court so that I can conduct the in-camera preference interview with the child prior to the hearing. If she could be here about 2 o'clock, that would be my ideal, so I can do that interview prior to the actual court hearing. All right. Any questions, Mr. Brandow?
No, Your Honor.
Ms. Nye, any questions?
No, Your Honor.
All right. I will see you both back here then in person on March 18th. Thank you.
Thank you.
And I'm sorry, it's Abear now. Ms. Abear, can you hear me okay? All right, I can't hear you, ma'am, because you're muted. All right, thank you.
I unmuted. I apologize.
All right.
I can hear you.
And Mr. Jarvie, can you hear me okay, sir?
Yes.
Thank you. And we are here today, Ms. Aber, on your motion regarding support. Is that correct?
Yes, correct.
All right. And what has changed to support your request to change the do a new support recommendation?
After I lost my job, I wasn't able to find another job. And when I had come in last time, my plan was to go to school to get more certification to become certified as a special ed teacher so I could get a teaching job, because my music certification isn't getting me a job within the 100 miles that I'm allowed to go. They keep hiring people straight out of college with no experience, and I have experience and degrees. So, but you said that the amount wouldn't be changed because I didn't have a new salary. So I got a job performing and also a job as a tester for a literacy nonprofit program. So I'm asking now, since I have income, for the amount to be changed based on what I'm making now.
Okay. And are you working? Excuse me. Are you working full time?
No, sir.
You're not working full time?
Nope. It's not a full-time job.
How many hours are you working?
Right now, for the past 2 weeks, I've been working over 35 hours a week, but it's only for 2 weeks now, then 2 weeks at the end of the marking period, and as needed in between. And I have a job for Easter Sunday as well.
Okay. And how much are you earning per hour?
$30.
Okay. For the court, the last calculation, do you know how much per hour that was based on?
Yes, we utilize, not per hour, but we utilize based on our 2022 taxes, a specific amount. Do you want that amount?
Yes.
$36,406.86.
Ms. Aber, you're indicating that most you would work in a week is 35 hours?
Correct. But it's only for the beginning and the end of their testing sessions. It's not constant. So it's for 2 or 3 weeks in the middle of the year, the beginning and the end of the year. The contract only goes through June. So I'm hoping that I can be hired again in the sign. It only goes to the end of this year, school year. I'm continually looking for teaching jobs and applying for all that are available as well.
All right. Well, I would still have to impute you to a full-time job. So what I'm trying to figure out is where we're at. If you're making $30 an hour, but that job you cannot do full-time. Is that what you're saying?
Correct.
It's just not offered to you?
Correct.
Do you have any other job to make up the?
I only have the performing job set up right now. Music performance.
All right, Mr. Jarvie, any comments or anything that you'd like to say on this issue?
Yes, quite a bit. First of all, I encouraged Ms. Aber to consider being a substitute teacher back in the fall, back when we were previously in court. It would have been something she could do 5 days a week, pretty much guaranteed. Especially in the Gaylord schools, there's a huge need for subs. So I encouraged her to do that. That would have been something that she could immediately do to support herself and our daughters. She obviously chose not to pursue that. The other thing that concerns me is she has not tried to work from last May, when she was unemployed, up until the beginning of this month. So my concern is there wasn't much of an effort there to try to find income, even if it wasn't the type of income or job description she was looking for. So from my standpoint, I'm concerned that there wasn't much of an effort or intent to find some kind of work until, recently, when she was able to obtain this position she's in now.
All right, thank you. All right, so Ms. Aber, you're asking the court to base your income only on the, sounds like you work about 2 weeks a month, is that correct?
2 or 3, yes. And they can take into consideration my salary at my last job for last year as well. I'm fine with that.
Okay.
I work as a teacher from January through April. April 19th when I lost my job. And I did start working at the end of December and the end of January. And I have been applying for jobs, interviewing for jobs, and continually working to get a full-time job, doing what I have my master's degree in.
Okay. All right. So what the court has to look at is when somebody is not working full-time, or even if they are working full-time, is whether or not they are either underemployed.
So am I working enough, or do we need to add substitute teaching also on the days that I can't work as a tester?
Well, if you came to us with, okay, I'm earning this much a month and I'm working full time, then we can consider that amount as your monthly income. The difficulty now is that if you're not working full time, but you're working a job that is paying you $30 an hour, I think if we put $30 out as a full time, $30 an hour full time, it might even exceed what our last calculation was.
Which most definitely.
But you're not doing it.
Correct.
But you're not doing it full time. So I think at this point, I'm going to deny the motion and go with the last figure that was imputed. If at some point you are working, 2 jobs that add up to full time, and that amount is less than what the calculation is, I would certainly consider revisiting the calculation. But given that right now you don't have full-time employment, I am going to deny the motion and continue to impute based on the last calculation that was made. Any questions, ma'am?
Mr. Jarvie is retiring. Will the child support amount still be based on what he's capable of earning, or is it going to be based on his retirement pay?
We would address that upon his retirement.
Okay. And what if I want to ask for permission to go beyond the 100 miles so that I can find a job that pays me full time to do what I do as a music teacher? He won't allow me to go past the 100 miles, which only gets me to Claire.
You'd have to file you'd have to file a motion if you want to change the domicile.
What court do I file that motion with?
This court right here. You start with the front of the court. Okay. They have the paperwork at the front of the court office.
Okay.
All right. Thank you both for appearing. That does conclude this matter.
Thank you.